just changed the security deposit rules again. If you don't know the new limits, you're one tenant dispute away from a lawsuit. This isn't theoretical. Every year, thousands of California landlords lose money in small claims court because they failed to understand or follow the state's security deposit laws. You think you're protected because you have a lease? Think again. The rules are designed to protect the tenant, and your ignorance costs you. You're leaving money on the table, not by charging less, but by losing cases you should have won or by paying out penalties you could have avoided. As of July 1, 2024, California Assembly Bill 12, AB 12, fundamentally alters how much you can charge for a security deposit. Previously, you could charge up to 2 months' rent for unfurnished properties and 3 months' rent for furnished properties. That era is over. Now, the maximum security deposit you can collect is 1 month's rent, regardless of whether the unit is furnished or unfurnished. This applies to all residential tenancies, even if you've had the same tenant for years and previously charged more. If you collected more than 1 month's rent before July 1, 2024, you are not required to refund the difference for existing tenancies. However, for any new tenancy or lease renewal occurring after that date, you must adhere to the new 1-month cap. If you try to collect more, your lease provision for the security deposit is void, and you could be forced to return the entire deposit alongside potential penalties. For example, if your rent is $2,500, your maximum security deposit is $2,500. Charging $3,000 puts you in violation. This isn't a suggestion, it's the law. Now here's where it gets interesting. What about last month's rent? Many landlords mistakenly believe they can collect 1 month's rent as a security deposit, plus an additional month for last month's rent. AB 12 explicitly states that security includes any payment, fee, deposit, or charge, including an advance payment of rent, used or to be used for any purpose. This means if you collect last month's rent up front, it counts towards your 1-month security deposit cap. So if your rent is $2,000, you can collect $2,000 as a security deposit, or you can call $1,000 a security deposit and $1,000 last month's rent, but the total cannot exceed $2,000. Don't try to circumvent this by labeling it differently. Courts will look at the substance, not the label. Understanding what you can and cannot deduct from a security deposit is critical to avoiding disputes. California Civil Code Section 1950.5 specifies 4 legitimate reasons for deductions: unpaid rent, cleaning the premises to its condition at the beginning of the tenancy, minus normal wear and tear, repair of damages beyond normal wear and tear, and, if provided in the lease, restoration of personal property, excluding normal wear and tear. But wait, there's a catch. The phrase normal wear and tear is where most landlords get tripped up. Normal wear and tear refers to the deterioration that occurs with the regular use of the property. Think faded paint, minor scuffs on walls, worn carpet in high traffic areas, or loose grout. These are not deductible. Damage, however, is your tenant's fault. A hole punched in a wall, pet stains saturating the carpet, a broken window, or missing fixtures. A landlord once tried to deduct $500 for excessive wall cleaning from a tenant who lived in a unit for 5 years. The judge ruled against the landlord, explaining that 5 years of occupancy naturally leads to some wall discoloration and minor marks, which constitutes normal wear and tear. The landlord ended up returning the full deposit and paying the tenant's legal fees. Your lease might say the tenant is responsible for all cleaning, but the law overrides that. You can only deduct for cleaning required to restore the unit to its original cleanliness, not to a pristine, brand-new condition. You have precisely 21 calendar days from the date your tenant vacates the property to either return the full security deposit or provide an itemized statement of deductions along with any remaining balance. This isn't 21 business days, it's 21 calendar days. Miss this deadline and you could forfeit your right to make any deductions, regardless of how much damage the tenant caused. Let's be clear, an itemized statement isn't just a number, it must be a detailed breakdown. For every deduction, you need to include the nature of the repair or cleaning, the estimated or actual cost, and copies of invoices or receipts. If you did the work yourself, you must provide a good faith estimate of the hourly rate and the time spent. For example, if you deduct $150 for patching and painting a hole in the wall, your statement should list wall repair, patching and painting bedroom wall, minus $150, attached, invoice from Speedy Drywall Repair dated mm/dd/YYYY, or, if you did it yourself, landlord labor for wall repair, patching and painting bedroom wall. 3 hours at $50 per hour equals $150. Failure to provide this level of detail or failing to include supporting documentation is a common reason landlords lose in court. A simple note saying repairs, $700, will not hold up. To legally deduct for damages, you need proof. The best proof you have is a thorough move-in and move-out inspection. California law requires you to offer your tenant a pre-move-out inspection, often called an initial inspection, within a reasonable time before the tenancy ends, typically within 2 weeks of the anticipated move-out date. You must notify the tenant in writing of their right to this inspection. Why is this crucial? It gives the tenant an opportunity to remedy identified deficiencies before they move out. This reduces your potential deductions and, more importantly, reduces disputes. During this initial inspection, you create a list of repairs or cleaning that the tenant is responsible for. You must provide the tenant with an itemized statement of these potential deductions. If the tenant fixes the issues, you cannot deduct for them. If they don't, your documented initial inspection report, combined with your final move-out inspection, becomes ironclad evidence. One landlord, faced with a tenant who punched multiple holes in walls, meticulously documented the damage during the initial inspection, noting each hole. The tenant did not repair them. During the final inspection, the landlord photographed the unaddressed damage. When the tenant disputed the $800 deduction for wall repair, the landlord presented both inspection reports and photos. The judge sided with the landlord, citing the clear documentation process. Without that initial inspection, it's often your word against theirs. Let's be direct. You're losing money by making these avoidable mistakes. The biggest one, bad faith retention. If a court finds you withheld a security deposit in bad faith, you could be liable for up to twice the amount of the security deposit, in addition to the actual damages. This means, if you improperly withheld $1,500, you could end up paying the tenant $3,000 plus potentially their legal fees. This penalty is designed to punish landlords who intentionally or negligently disregard their legal obligations. Another common pitfall: deducting for carpet replacement after only a few years. Carpets have a depreciable life. In California, the useful life of carpet is generally considered 5 to 7 years. If a tenant lived in your unit for 6 years and the carpet was already 3 years old when they moved in, you cannot charge them for a new carpet, even if it's stained. You might be able to charge for the asterisk remaining useful life, but not the full replacement. For example, if a carpet has a 7-year life and the tenant stayed for 5 years, you could only charge for 2/7 of its replacement cost. Assuming the damage was beyond normal wear and tear, many landlords try to charge for a full replacement and get burned. Similarly, charging for a full paint job after a long-term tenancy is often deemed bad faith. Paint typically has a useful life of 2 to 3 years. If your tenant lived there for 5 years, you cannot charge them for repainting due to normal wear and tear. Finally, remember that the security deposit belongs to the tenant until you prove your right to deduct from it. It's not your money to hold on to indefinitely or to use as general income. Treat it as a trust fund. Failure to comply with any of these rules, the 1-month limit, the 21-day return, proper itemization, or the initial inspection offer, can lead to significant financial penalties. California courts are not sympathetic to landlords who claim ignorance of the law. Your responsibility is to know and follow these rules. Recap: to protect yourself and your investment, remember these critical points. First, as of July 1, 2024, California caps security deposits at 1 month's rent. No exceptions. This includes any advance rent payments. Second, you have exactly 21 calendar days after your tenant moves out to return the deposit with a fully itemized statement and supporting documentation. Third, you can only deduct for damages beyond normal wear and tear. Faded paint or worn carpet in high traffic areas are not deductible. Fourth, always offer and conduct a pre-move-out inspection. This gives your tenant a chance to fix issues and provides you with crucial documentation. Lastly, understand that bad faith retention can cost you twice the deposit amount in penalties plus legal fees. Don't gamble with your bottom line. Powered by LeaseBase Intelligence.